The Administration of Criminal Justice Act was enacted in 2015. There are bodies that the Act set up for the monitoring and successful implementation of the Act. One of such bodies is the Federal Justice Sector Coordinating Committee. In furtherance of its responsibility to monitor the implementation of the Act, the committee moved to the northeast geopolitical zone of Nigeria, where it brought together all actors in the justice sector in the 6 states of the zone. In this edition of The Scale, we shall be looking at the peculiarity of the implementation of the Administration of Criminal Justice Act in the northeast states. Welcome to the program. I am Femi Okeowo. This is the 4th zone being visited by the Justice Sector Coordinating Committee for the workshop, which drew a high level of participation from all the 6 states in the Northeast, bringing together the police, correctional centers, Legal Aid Council, Nigerian Bar Association, and prosecutors from the ministries of justice of the various states.
This workshop attests to the determination of the Federal Ministry of Justice through the Federal Justice Sector Reform Coordinating Committee to continue to lead the effort towards reforming the criminal justice administration and promotion of the rule of law. Following the validation and adoption of the reporting templates and arrest protocols at the National Workshop held in November 2018 in Abuja by the heads of the various justice sector institutions involved in criminal justice administration, led by the Chief Justice of Nigeria, it became imperative to train those saddled with the responsibility of actual implementation of the Act. The Act has provided a broad legal framework for a more effective cross-sector collaboration and oversight between and amongst agencies in criminal justice administration and the protection of the rights of citizens. Section 29, subsection 1 of the Act provides for a mechanism for interface between the Inspector General of the Police and the Attorney General of the Federation, as well as the Commissioner of Police and the Attorney General of the states. The section requires the Inspector General of the Police to remit quarterly to the Attorney General of the Federation a record of all arrests made with or without warrant in relation to federal offenses within Nigeria, while Section 29(2) requires the Commissioner of Police of the state or head of agencies authorized to make arrests to remit quarterly to the Attorney General of the state records of arrest with respect to the state offenses. Section 23 of the Act requires an officer in charge of a police station or an officer in charge of an agency authorized to make arrests to, on the last working day of every month, report to the magistrate the cases of all suspects arrested without warrant within the limit of their respective stations or agencies whether the suspects are admitted to bail or not. The form and content of such report is provided in Section 15 of the Act. This training workshop, organized by the Federal Justice Sector Reform Coordinating Committee for the Federal Ministry of Justice. It's about implementation of the Administration of Criminal Justice Act and similar laws in our various states. The Federal Ministry of Justice spearheaded the adoption of this law, the Administration of Criminal Justice Act, in order to attend to the many challenges of criminal justice administration in our country and to upgrade the criminal justice system so that it can meet the challenges of today. But you know, it's not just enough to pass a law. The real challenge is implementation. So since 2018, the Federal Ministry of Justice has been organizing various training programs in order to facilitate the implementation of that law.
The workshop was facilitated by the Federal Ministry of Justice with the assistance of European Union and the British Council.
So these sections we're talking about, sections 29, 33, and 34, provide an important feedback mechanism for those who sit on top of the entire criminal justice system. And by this, I mean the Attorney General of the Federation, I mean the Chief Judges of the federal, of the various states here present, as well as the law enforcement agencies here, the heads of the law enforcement agencies here. It's to provide them with a very, very effective feedback system that helps them to track what happens in the system and see how effective the processes they put in place are to address issues about criminality, but also to ensure that in addressing those issues, the rights of citizens are not trampled upon. And we believe that when these provisions are effectively implemented, then we can see a more efficient criminal justice system, efficient in the sense that it promotes timeliness, the will of justice granted in a faster manner, but also importantly, the rights of suspects are respected and upheld.
With the formal ceremonies over, the scale sought to know how successful the Justice Sector Coordinating Committee had been in monitoring ACJA's implementation, particularly in view of the peculiarity of the Northeast geopolitical zone. Are there peculiarities with zones in the difficulty of the implementation, or have you noticed that there's a generality of or uniformity in the difficulties and implementation?
There are both common problems across the nation. When you introduce reforms and the issues they address are problems across the nation. The question of how people are arrested and how they are detained and how the Constitution and their fundamental rights are respected when investigation is going on and they are being prosecuted in the courts. We know that there is this common problem of delay across the country. But there are also, as you go from region to region, peculiar issues. For instance, now in the Northeast, we know that a significant part of the Northeast is facing this problem of insurgency. So the challenge of ensuring protection of rights of people in an environment of conflict is an issue in the northeast of Nigeria, in Adamawa, in Yobe, in Borno, where large number of people have been arrested in relation to the insurgency, and then there's a policy. both in the Administration of Criminal Justice Act and in other laws in Nigeria, and also policies of government, federal government, on how people are to be sorted out. It's not, everybody who is arrested is a terrorist. It's not everybody who is arrested is is an insurgent. But the very nature of military operation in this kind of environment is such that the society as a whole is bound to be affected. So here in the Northeast, there is the challenge of ensuring that extra steps are taken to protect the rights of innocent citizens so that they are not affected by the war against the insurgents in a negative way, or they have been arrested, detained, and probably taken for terrorists.
Even at the best of times, the implementation of Section 29, 33, and 34, you must have seen, it needs a little more push. But with the peculiarity of the Northeast now, it would seem as if those sections would suffer particular neglect.
That is a fact in the sense that, those sections call for collection of data and information on people who are arrested, keeping good records of the arrest, transmitting those records so that there is monitoring and tracking by the higher authorities, particularly by the attorneys general, by the Administration of Criminal Justice Monitoring Committee, usually headed by the chief judge. And also there is opportunity for magistrates to receive information on records from police stations and to visit and inspect those police stations. Now, ordinarily, this will be about police. But in the circumstances of the Northeast, the detention, the arrest is not done by police alone. There are a large number of bodies and institutions that are involved. In particular, the military also arrests, has detention places. You also have the other law enforcement and security agencies like the DSS, like the Civil Defense Corps, and even in terms of the NDLEA, in a situation of conflict, you are likely to have escalated and aggravated use of drugs and all that. So to have the capacity to inspect those places, to keep the records, is a very challenging assignment for our judiciary. And so this means that you need skill within the judiciary for this to be done, and that's why in the training we are doing, we have developed templates and tools that the judiciary will use. There is also, the challenge of ensuring that you have access, and in a situation of military operation, of insurgency, there are all kinds of restrictions. So for us there is need for full engagement, not only with the police, but also with the military and other security agencies, to say that the laws that we have that call for protection of human rights for people who are arrested and detained is not limited to arrest by police. It extends across the board. It is about fundamental rights in the Constitution of Nigeria, which everybody, including the military, is supposed to respect. And the Administration of Criminal Justice Act makes provision for ensuring that there is a good tracking of these arrests, and there is inspection of conditions of detention, and that this does not matter who the detaining authority is. So you can see that in this environment, we need to make more efforts, we need to build more skills, we need to create better understanding in the relationship between institutions for those aims of the law to be achieved and for rule of law to be maintained.
the Administration of Criminal Justice Act is about going to 6 years old now. And yet there are still some provisions, as we have seen in this workshop, that we are still striving to implement. Why is that so?
The state also have their own administration of criminal justice law, which they have also passed, which they are implementing. So the Act, as a federal instrument, as a federal legislation, is the one we at the federal level are driving the implementation. And this is so because there are certain provisions of the Act that has national application. The sections that we are specifically implementing, section 29, 33, and 34 of the Act, adds provisions that provides responsibility for federal institutions that the states lacks power to legislate upon. So those provisions are provisions that has national application. And that is the reason why we are driving the implementation of those provisions across the country.
Other stakeholders also spoke. Give us your impression that a workshop like this is being held for all the Northeast participants in the Administration of Criminal Justice Act.
Yes, this is a welcome development. It will enhance the speedy implementation of administration of criminal justice in the Northeast generally. And another important milestone is that among the participants, the major stakeholders is the investigators or police prosecutors, because the sections that are to be implemented, so to speak, majorly they are the major target, so to speak. Before they are going to be the first contact with the suspects. So issue of taking statement, the presence of a legal practitioner, in the participation of legal practitioner during the recording of the statement of the suspect, and also using equipments, the gadgets that are needed to record the statements. But my own additional, based on my own experience, the most important thing is that policemen or law enforcement agents generally should not focus on extracting confessional statement of the suspect. The most important thing is that, as an experienced defense counsel, I noticed that policemen, they generally rely on that confessional statement. So I'm encouraging the police to go outside confessional statement, at least get evidence outside confessional statement, such as you get circumstantial evidence, to be able to nail the suspect instead of relying on confessional statement.
Justice is supposed to be seen, done, and implemented. And part of what the Honorable Attorney General of the Federation and Minister of Justice, Abubakar Malami, stand firm to ensure is the administration of criminal justice and, in general, speedy dispensation of justice. There are observations regarding delays in justice dispensation, issues regarding arbitrary arrest, issues regarding the respect for human rights or rights of the suspects, because suspects are considered to be innocent until proven otherwise. And also the issue of transmission of information across all the stakeholders concerned. It is on the basis of that, in order to ensure a harmonious working relationship and to ensure speedy dispensation of justice and to ensure that all the extant laws are being taken care of and are being considered. So it is realized upon that there was need to have a more sensitized stakeholders, and that informs the reason why these workshops have been organized.
The monitoring of the ACJA implementation continues, and you can be sure that the scale will continue to be part of it. Now, another area that deserves close monitoring is the law that prohibits torture in Nigeria. Recently, some organizations, such as the Federal Government Anti-Torture Committee, PRAWA, Clean Foundation, and Amnesty International, brought together allied bodies in Abuja to assess if torture is still an issue of concern in Nigeria. Let's look and hear part of the submissions at that workshop.
Whatever we have been doing that seemed to be just symbolic, but not really meeting the nitty-gritty of what we require, can no longer continue. It's not about making laws. It's not about establishing committees. It is about matching our intent with action. Actions that come with providing funds, actions that come with establishing processes that can check, that can demand accountability. Processes that are transparent, but processes that recognize that the citizens have a voice to demand better treatment, better governance. We've been told that there is a need to engage, and engagement we must ensure should happen. Things may not change unless people decide to make that change. And oftentimes, it may not be too many people, but certainly those who recognize that there is a need to have change, who are passionate enough, who are committed enough, who recognizes that little steps can make certain impact. Can you listen to the wonderful presentations that came from this side? Did you listen to what came from the other side? What are we lacking? What are we lacking? We've heard also that when you make some successes, don't go down back. Just make sure you drive it home. I'm sure this is not the first time we are hearing the kind of things we had in this room. But maybe, only maybe, it may be an opportunity for all of us to now take action and say, on our own little space, it may be small, but let's do something. Let's do something. What you will do is left in your hands. But I tell you, there are some people who will make a commitment. I'm, for one, making a commitment today that wherever I can, I will make my input. And I know that if the same commitment all of us are making, let's make tomorrow better.
That's so much we have for you on the scale today, where we have taken a trip to Yola, where we also have monitored how the implementation of the Administration of Criminal Justice Act is going on in the northeast states of Nigeria. We also have looked at torture as a concept and as a dreaded issue in the criminal justice sector of Nigeria. We shall be unveiling other issues of concern in the justice sector in the days to come. I hope you will always join us as you have done today. We'll see you again.